The Constitutional Court is hearing a hate speech case that could have far-reaching implications. The matter dates back to 2009 when Cosatu's Bongani Masuku was found guilty by the Equality Court of hate speech for comments he made about the Jewish community. But the SCA overturned the ruling. Now the Apex Court is being asked to correct this. Janke Tolmay has the details.
I can fully understand that many people want clarity on the constitutionality of Section 10 about its proper application and interpretation. And that's probably, I fully understand why we have 6 friends here interested in the matter. But our submission is that this must not distract from what is ultimately the factual inquiry which arises in this case.
These facts the Constitutional Court has heard are based on the arguments that Bongani Masuku did not commit hate speech. One of his comments made at a pro-Palestinian rally was that, quote, any South African family who sends its son or daughter to be part of the Israeli Defense Force must not blame us when something happens to them with immediate effect. Now, the Supreme Court of Appeal found that while these might be offensive, it forms part of a political stance against the state of Israel, which falls under the freedom of expression. But the South African Human Rights Commission insists Masuku's use of coded language can't be interpreted in any other way than being directed at the Jewish community. This case can also have further implications, as it is the first substantive hate speech case before the Apex Court. It's being asked to correct the judgment by the Supreme Court of Appeal, which relied on Section 16 of the Constitution instead of relying on Section 10 of the Equality Act, which goes much further around the issue of hate speech.
It is our submission that unless this preoccupation with Section 16(2)(c that is traced throughout the Supreme Court of Appeal's judgment is not set straight by this court, it will severely retard the constitutional project that lies at the base of the Equality Act.
Judgment has been reserved. Janke Tolmay, Constitutional Court.